My name is Rachel Mason. I am the program manager at the Karuna Center for Peace Building, with apologies from Olivia Dreyer, our executive director, who wished she could be here tonight, but was unable to make it. So the Karuna Center for Peace Building, as some of you might know, primarily works in programs overseas. Our mission is to empower people divided by conflict to develop mutual understanding and to create sustainable peace. But we don't need to be overseas to find opportunities to create mutual understanding and work towards sustainable peace. We've been partnering with Critical Connections for a number of years, and we started the series that we've been referring to as Transforming This Moment a couple years ago, or right after the 2016 election. We've moved on to building inclusive communities, but we keep getting pulled back to this idea of transforming this moment because the moment has not yet been transformed. We have work to do, and we have a collective responsibility to do that work. That begins with us knowing what is happening now before we can do the transformational work. We need to work at exposing what's been going on. We need to be doing some work in thinking about what kind of society we want and what kind of future we want. So our series this year will continue to fall under the theme of transforming this moment. We've come up with the title, what did we decide it was? Examining Our Collective Responsibility. Our next event after this one, which I'll speak about in just a moment, will be next month, February 27th. Please join us to welcome Shaheen Pasha and hopefully a few other speakers to discuss the Me Too movement from a minority voice. Shaheen Pasha is a Muslim journalist, and she'll be giving us some of her perspectives on that moment. In hopefully the end of March, we'll have David Mendikoff speaking about U.S. policy in the Middle East. April and May events might not fit this series so much. In May, we hope to bring back our next symposium on building inclusive communities. And in the fall, we hope to continue this series with topics that might include drones, criminal justice system, reparations, safe communities, or anything else that falls under this category. If you have suggestions of topics you'd like to have us discuss, please let us know. Make sure to leave your email address if you'd like to stay informed about future events. But first, to talk about tonight's event a little bit, I have not read this book, so I won't be doing any of the introducing. I did see The Post this weekend, though. And I don't know how many of you have seen that movie yet. But while watching it, as a friend of mine commented, it didn't matter one whit that you knew how it was going to end. And part of the reason that it was such a compelling film is that even though we know how things turned out in 1971, 1972, we don't really know what's happening now. We're in a similar situation in some ways. The press is under attack. There are secrets that we know nothing about. So with that in mind, I think that tonight's event is particularly timely, and I will leave it to Mehlika to introduce our speaker with a little more detail about what she does.
Great. Thank you so much, Rachel. Good evening, everyone. My name is Mehlika Samdani. I'm the Executive Director of Critical Connections, a nonprofit organization here in the Valley. We put together events in partnership with the Karuna Center on issues related to Muslim communities and also other targeted communities. I'm especially grateful that you're all here today because we knew that we were competing with the State of the Union address. However, for all of you who are here, I can assure you that you will get a better sense of what the state of our union and our democracy is from our speaker right here than you would if you had stayed at home. And so, as Rachel mentioned, our event today is focused on government secrecy surrounding national security and counterterrorism issues, and what the implications of that is on our democracy. And I can't think of a better person to address this very complex subject then our speaker today, Professor Sudha Setty, who's done extensive research and has so much scholarship around this issue, and recently came out with a book called National Security Secrecy. It was published by the Cambridge University Press last year. And if you don't already have it, I would highly recommend that you do find it on Amazon and get it, because it's such a comprehensive analysis of the kind of secrecy that has shrouded our national security policy over the past few decades. So before I introduce Sudha formally, I would just like to say that, as many of you know, she's a law professor at Western New England University. But I'd like to share some good news, and this is hot off the press, that she was just appointed the Dean of the Law School at Western New England. So, about that. So I will read from her bio, and I will just quickly also tell you how the evening is going to unfold. So for the first maybe half an hour to 40 minutes, I'm going to ask her a series of questions, and then we will break up into small groups and really engage with the subject and each other, and before reconvening as a large group and then having an hour-long Q&A with Professor Setty. So by way of introduction, Professor Setty, as I've already mentioned, is a professor of law at Western New England and has twice won teaching awards. She teaches law and terrorism, comparative constitutional law and civil rights, business organizations and contracts. Her scholarly work focuses on comparative analysis of separation of powers, rule of law, and national security issues. And she currently serves on the editorial board of the Journal of National Security Law and Policy. Professor Setty graduated as a Harlan Fiske Stone Scholar from Columbia Law School and received her BA in History with a concentration in comparative civil rights with honors from Stanford University. Sudha, welcome to our event.
Thank you for having me.
So we'll just get right to what you've sort of grappled with in your book. And in your book, you describe how since 9/11, successive US administrations have grown increasingly more secretive. And you argue that this has undermined rule of law and democratic norms in our country. How so?
So one of the basic tenets of liberal democracies is that people should understand what their government is doing, right? The whole idea of being able to hold your government accountable through elections, through investigation and oversight, through whatever other means you have, you can't really do that unless you know what the government does. And with non-national security areas in the law, I think we've struck a different balance where sometimes that oversight goes forward. It might take a couple steps back depending on which administration we're dealing with. So for example, the Obama administration tried to be a little bit more transparent in different areas like energy policy, the work of the EPA, other departments like that. The Trump administration has not really done that. In its administrative agencies all across the board, it's been more secretive and releasing less information about the goings-on inside the administration. In the area of national security, there is perhaps a good argument that you want to have less transparency, right? That I think most people could agree if there's strategic military decisions being made, you don't necessarily want to have your highest level of government transparency around those decisions. If there's sensitive classified information about a military program, there are good reasons to keep that quiet, at least for some time and to some extent. If there's information about the identity of US operatives overseas, those are things that should be kept secret, again, at least to some extent and for some time. I think one of the problems here is that since September 11th, all three of the administrations that we've had have used national security as kind of a magic, saying to try to get courts, to try to get Congress, and to get the public to say, oh, well, we don't really need to investigate. I guess we don't really need to know, because if we do investigate too much, we might be undermining our national security, right? That's really how the conversation has gone. And the problem with that comes back to what I said right at the beginning, that if you expect to be able to hold your government accountable, not just for the decisions it makes every day, whether you think that they're wise or correct decisions, but also for things like fraud and abuse, or in the case of our kind of post-September 11th counterterrorism framework, things like detention in black sites, or the use of drones overseas to engage in targeted killing, or how it is that we account for data gathering and privacy concerns on Americans and non-US people. If you have concern about abuses in the way that the government conducts itself, you need that transparency to be able to understand that and to curtail that. That's a democratic value. And so that's really the argument that I make overarchingly in the book, that we've allowed for too much of this, and what happens is not necessarily a great increase in security, but we have lost a lot of the kind of democratic accountability that we would have hoped for.
And so does this, you mentioned 9/11, but does this also predate 9/11? And can you sort of give us like a historical overview very briefly about how we got to this place where now national security policy has become so opaque that it's sort of difficult to penetrate through?
Yeah, I think these things have gone in waves. I would identify with the kind of current era, the post-World War II movement towards creating agencies like the National Security Agency and the CIA and other agencies like that. And I don't actually, I don't have an opinion on whether it was right or wrong to create those agencies to do some work. Really, my question is why it is that Congress was unable to kind of keep hold of some control mechanisms on the work that these agencies do. But I think in that kind of early Cold War moment, there was a great deal of concern about infiltration in American society of people who were spies or people who were disloyal to the US government. This fear of espionage, I think, was rampant and it particularly took hold in Washington. And it built up over time, right? These things feed on themselves over time. And if you never allow for those abuses to come to light, you don't get the pushback to suggest that the structures that you've created are unnecessary. After Watergate, certainly a bunch of mechanisms were put in place to try to improve accountability over the executive branch. There's a little bit more transparency and oversight, but then again, and that has a kind of mixed record through the 70s, 80s, and mid-90s. Even before September 11th, as you're suggesting, it's not as if the transparency levels over security matters were great, but there was perhaps a little bit more give and take between Congress and the executive branch. After September 11th, there was a great deal of fear, right? Fear of another terrorist attack, for sure, as a fundamental fear, but also fear of getting blamed for future terrorist attacks. And so for Congress or the courts or even the public to some extent, there was a view of, well, we don't really need to know, you go ahead and do what you need to do. And I think that has been prevalent. There have been a few moments in the post-September 11th context where we've gotten pushback on that, and we can talk about that later if you want. But the idea that it started decades before, I think, is important to understand the context.
Right, and so the other thing in your book that you sort of talk about, this other trend that has emerged is, so on the one hand, the administration or the executive has become more and more secretive. And at the same time, sort of simultaneously, they're trying to curtail the right to secrecy of individuals. So by, increasing surveillance and by sort of undermining people's privacy, they've done that. But sort of coming back to what you just said about, people sort of relinquishing their right to privacy after 9/11, and the fact that, just recently, I think it was last week or a couple of weeks ago, that Congress authorized Section 702 of the FISA, the 2008 FISA Amendments Act, which basically allows the government to surveil not just foreigners, but also Americans interacting with them either through video chats or phone or email or whatever. So just the fact that Congress has allowed for that to happen, the fact that poll after poll, we find that Americans are willing to relinquish their privacy in order to enhance their security. So why should the government alter its course?
Yeah, you raise a couple of really interesting points. First, I think, I don't think it's 100% clear that the US public fully understands what information is being gathered, how it's being held, how it's being used or could be used by different government agencies, and who has access to that data. I don't think that story is fully out there in understandable terms, and I totally understand why. It's not particularly glamorous. It's not setting aside a couple of engaging videos by John Oliver and other folks. Like, it's not that easy to particularly understand this. So I totally understand that. And I do think that there's somewhat of a false dichotomy that most people will trade off this idea of trading off security and privacy. I think this is, if you set it up, if you ask a question that says, will you do X if it will save your life? Most people will do whatever that X is, right, within certain limits. But that's not the right question, or at least it's not the right question that should be asked of people. If the question is, does this program work to increase security in the sense of giving valuable data that has proven over the years? We've had the FISA Amendments Act for some time now, Section 702 for some time. Do we have proof that it has helped in giving valuable data? Not necessarily kind of the headline way of like, how many terrorist threats has it disrupted, but have you been able to infiltrate a network using this data? Have you been able to determine which areas of which countries are in high recruitment zones? Is there valuable information that's coming forward? If you're able to answer yes to that, and then you can look at it and say, okay, now is this program also run in a way to minimize the risks to privacy and civil liberties, in a way that you can justify whatever compromise you've made on those grounds because of the value of that program? Then, if you have both of those things, then let us consider openly and transparently whether this program makes sense. Let's have that debate on whether we want to have that program in place. But the debate over Section 702, it doesn't follow that kind of trajectory of debate, right? Instead, this particular section, which at least it was kind of hotly debated here a little bit more than it might have been 5 years ago or 10 years ago. This particular section, which is geared towards gathering foreign surveillance, right, about people who are non-US persons, which just means someone who's not standing in the United States or doesn't have US citizenship or status and who's overseas, right, those folks. It's geared towards gathering their data, but anytime any one of us has that video chat or whatever else you're talking about and we happen to be here, our data gets scooped up too. And so the argument here is, well, you're really getting a lot of information on US persons when you have this kind of provision in place. So having an open debate on what the value of that program is and how much you could change it to try to help protect people's civil liberties, I think would be a really good conversation. So Senator Markey was here the other day. A bunch of the folks in this room, I remember seeing you there at his town hall meeting. And afterwards, one of the questions I asked him was, first to thank him for his vote on 702 to try to not vote for the reauthorization. But I asked him, well, why do you think so many of your Democratic colleagues peeled away from the Democratic caucus on this one and voted to renew this act? And he said, people are afraid, and the administration makes them afraid by telling them that if they don't renew this, it's going to cost American lives. That's the line that they use all the time, and it still works even though it's been 16 years since September 11th. So we're not having the debate about kind of the complexity and nuance of these statutes. We're having a very different debate that says, well, don't you want to save people's lives? And that's not the right question to ask, but it's the same question that we keep asking.
Right. So, what models do we have, from other countries, other democratic countries who've sort of, maintained this balance between secrecy, security, and also surveillance?
Yeah, you ask a hard question, right? It's something that I take up in this book because a lot of my research focuses on, well, are there other countries that strike a better balance than we do? And if so, how do they do that? How do they get there? And I talk about the European Union and then the UK and India as some comparator nations here. The European Union, if we're thinking about those of us who would like to see more privacy protective laws and jurisdictions in place, the European Union does the best job out of all of these. Part of it is that it's not a particularly democratic institution, right? These rules are being decided by judges who are often from different nations than the peoples who are being subject to their jurisdiction. There's a lot of anti-EU anger within the EU itself that judges from, who sit in different countries are making decisions about what we can do in Hungary or England or other places like that. And maybe it's because they have that removal, that they have the freedom to do this, but they've been very privacy protective. They, in fact, had decisions in late 2016 and early 2017 coming out of the European Court of Justice that basically say, if you have surveilled anybody, even for national security purposes, you need to notify them after the fact when it becomes safe to do so. So maybe that's not immediately, but maybe it's 5 years down the road. And the idea of doing that is, and the courts say this very explicitly, there's going to be abuses anytime you let someone conduct surveillance on someone else. Anytime you enable a government to wiretap somebody or do whatever else, there's going to be something that might go wrong with that. So as a baseline matter, you need to notify someone that they've been subject to surveillance so that they can challenge it later on and tell you and fight it, ask for compensation later on if they feel like their rights have been violated. That's pretty remarkable. That's so different than how our law works here. It's really remarkable. And the UK is currently subject to this jurisdiction, at least while the Brexit negotiations are unfolding. And there's a lot of anger, a lot of the populist anger in the United Kingdom is because they don't like the idea of the EU imposing certain immigration obligations, security obligations, and civil liberties obligations on them. And so it'll be interesting to see how they change that going forward. The situation in India is actually significantly less privacy protective than even here in the States, in the sense that the government has explicit authority to wiretap and to actually scoop up the contents of people's phone messages, emails, any kind of text messages, to hold it indefinitely and to search through it for whatever reason they want to. Their nexus to even having to do it in the name of national security is really weak. So if they decide they think someone has been engaged in fraud or embezzlement, they can use that as the pretext to go through and search all of their emails. They don't need a warrant, they don't need anything else. So it's a much less privacy protective set of decisions right now.
Sure, great. And so we'll all have an opportunity to ask follow-up questions to these questions, but we'll wait until the Q&A session. But moving on, so what about the current administration? And it's only been around for a year, but what are your thoughts about their approach to secrecy? And what are some areas that you're particularly concerned about?
So, like I said earlier, I think one of my concerns about this administration is that they have a tendency to try to avoid transparency in lots of different areas, not just in the area of national security. They try to hide their practices from public view. And that in itself, it's not a singular administration for being kind of secretive. I think we've seen that in the past, it occurs. But the thing that is perhaps more remarkable about the Trump administration is that it's combined with a few other things. It's combined with a kind of disdain for expertise and knowledge that has been gained over years. We can see in the news over the last weeks and months about the number of people who are leaving the administrative agencies after long careers as apolitical civil servants because they can't do their work anymore, right? It's scientists at the EPA who have worked under Republican and Democratic administrations in the past who no longer feel like they have the tools to do their job, and that the oversight, the people who are political appointees above them, that they are not letting them engage in the work they need to do. So when you bring that kind of secretiveness with a lack of expertise in the sense that the experts are leaving or are not given weight to what they're saying, you combine that with how should we say, a loose adherence to the need of to promote the truth as a core value of government. I think that it's a recipe for dangerousness or for danger, and particularly in areas like national security, where we have not built up a good infrastructure over previous administrations to question what the government is doing and to understand fully what the dangers might be and where the abuses might be occurring. I think that you can see that in a couple of different things. I'll use one example right now, the situation with using drone strikes. As many of you may know, the use of drone strikes for targeted killings overseas increased dramatically under the Obama administration. It was used very widely. One of the issues that occurred in the Obama administration is that folks like the ACLU and other organizations kept asking, well, how do you determine who can be subjected to a targeted killing? How do you make that determination? And it took several years for the Obama administration to try to give some clarity to what standards they were using and what chain of command had to be in place to order that kind of targeted killing. But eventually that information came forth. With this administration, they basically revoked the Obama-era guidance, but they haven't told anyone what's sitting in its place. And in addition to that, unlike under both the Bush and Obama administrations, this administration is not actually telling people about civilian deaths for drone strikes. I mean, people question the numbers that were given by the Bush and Obama administration all the time, but they at least tried to give some numbers and the locations of strikes so independent investigators could go and see whether they thought that was accurate information or not. This administration is not doing that either. And so there's reporting that suggests that the civilian death toll has increased dramatically in the last year, but there's no government information available to do that other than going through litigation, which, as we all know, takes a long time to wind its way through the courts, especially if it's dealing with getting information and not some sort of immediate harm that might occur to someone in the future.
Right. There was just, I don't know how many of you heard that story on NPR this morning about, the war in Afghanistan, and apparently the Special Inspector General for Afghanistan Reconstruction does not even have all of the information about the war effort there and about how many people have been trained in the Afghan security forces and how it's going and what kind of attrition is happening. And there's been a lot of sort of withholding of information by the Trump administration in terms of, again, civilian casualties and also about the war effort, information that over the past 10 years had been made available to the public. So in that regard, and sort of regarding drone strikes, how do we then, as ordinary citizens, push back? And how have Congress and the judicial branch over the past year, how have they tried to sort of check executive overreach and sort of ask for more information?
In general, the post-September 11th trajectory is Congress and the judiciary really taking very tentative steps, if at all, to curtail what the executive branch can do in national security matters. And then, too, it has to be because there's a certain moment that is giving them the political will to do that. There's a few instances that have come up since September 11th that suggest, there's a potential for Congress and the courts to move the other direction. So after information about torture and CIA black sites became public, I think there was a public outcry. It led to more investigations. It led to Congress passing a Detainee Treatment Act in 2005, largely thanks to the efforts of Senator McCain to push through that kind of legislation. It was imperfect, right? It had loopholes and all kinds of things, but at least it was a moment of pushing back and then demanding information and reporting on how detainees were being treated, right? Then again, after Edward Snowden's disclosures regarding data gathering and surveillance, there was protests, there were lots of investigations, and even more so than in the torture cases, people actually got to bring their claims to court after the Snowden disclosures, and people got to say, hey, you're unconstitutionally surveilling me. The New York Times and and the ACLU and a lot of individual plaintiffs brought these claims, and some of them were successful. And what that led to was some courts really engaging with it, but also some reforms to how surveillance occurs. We had a law passed in 2015 called the USA Freedom Act that put some limits on this type of data gathering and surveillance. Not the Section 702 stuff that just got renewed, but some other types of surveillance. And that it also tried to create a little bit more transparency, saying, well, the NSA has to engage in more reporting than it used to on its activities, and Congress has to engage in more oversight. Those are good moments. And interestingly enough, I think early on in the Trump administration, we had a moment like that as well when the first of those immigration/national security entry bans went into effect just about a year ago now. And there was a public outcry, and courts all of a sudden stepped up, right, in ways that they don't normally do. I actually think that in a weird way, the silver lining of a lot of this kind of what we would used to consider very outrageous behavior from the administration, right, as something that seemed shocking, which I think many of us have grown desensitized to over the last year. But one of the silver linings of this kind of shocking behavior is that it has forced other institutions to take a more active role and to say, well, we're not getting the kind of self-policing that we would expect out of the administration. We've got to do more. We've got to step in. We haven't seen that from Congress really at all, but we have seen it from the courts and we've seen it from the public, which comes back to the start of your question that, courts in particular, they try to act really apolitical as if they have no, they're not swayed by what's happening outside their doors. But that's just patently untrue, right? They are deeply influenced by what's happening outside. And when there's a high level of understanding in courts that people care, that people think something is unconstitutional and they are willing to stand up for it, it kind of bolsters the willingness of courts to engage in these matters that they did not used to engage in. There have been 3 iterations of that travel ban now, and the language that's in the court opinions surrounding them is so different than anything that you've seen before in the Bush administration or the Obama administration. There are judges saying, you can't say national security, the words national security, and expect us to back off. That doesn't work, right? Which it used to happen, right? And it used to work really well. So I can kind of understand why the Trump administration was trying it. And now they're saying, you got to tell us why. Why in detail? Why these countries? Why are they restricted for travel into the United States? How did you get that information? On what basis do you think that restricting this kind of immigration is going to be helpful to national security? They're engaging in the type of conversation that I was hoping that we would have around Section 702. And it's been a real sea change. And so I think engagement from the public and continued pressure in the political process and whatever else will feed into the court's view of its own role here on how to engage on some of the more egregious aspects of the Trump administration's actions.
Great. So I'll ask the last question, because I want to give everybody an opportunity to sort of, engage with each other on this subject, but sort of given public activism in this current moment and the level of civic engagement that we've seen, are there current legislation sort of underway or being deliberated upon in Congress that we, can, as citizens or as constituents, can sort of promote or, sort of pressure our members of Congress about?
Well, this is a good question, and I think it kind of depends on what people are interested in focusing on. I think that there's a lot of legislation that has been tried to, at least in the last year, that kind of the progressive-leaning and libertarian-leaning members of Congress have tried to promote. I think this vote on 702 was a hopeful moment in the sense that you had left-leaning Democrats, and you also had kind of the Rand Paul vein of libertarians in the Republican Party who were trying to come together to push back against this. And I think to the extent that any more legislation is raised that kind of falls into that category of allowing for that kind of coalition building, it's really necessary and would be a useful place to push. There's not any that are on the horizon the same way that 702 was. And the reason I think that that's most fruitful right now is, A, it takes out the partisan angle in suggesting that this is not something that is purely a Democratic move to undercut President Trump or something else. It suggests genuinely that people across the political spectrum care about these issues, which I think is true. And B, one of the benefits it would have there, if it can gather Republican sponsorship, is actually move it further through the process than might otherwise be possible. I think one of the difficulties with these kind of more technical bills is that with the kind of, what's the analogy that people have been using? It's like trying to, drink from a fire hose sometimes when there's 40 issues coming at you from the administration. Trying to select one and deal with it is often difficult. So I think it does take some thought in terms of public mobilization.
Well, I think what we'll do is sort of pause over here and maybe break up into small groups. And what we're sort of envisaging for this part of the program is to maybe just, talk with each other in maybe groups of 5 or 6 about how do you sort of see this trade-off between security and privacy. And how has this conversation or insights from Professor Setty, how have they informed your views about what kinds of legislation you would like to see, in the political realm. So I think we'll maybe take about 15 minutes for, have small group discussions, and then we can reconvene for a Q&A session with Professor Setty. Does that sound okay? Okay, well, thank you all so much. It sounded like everybody had some great discussions. And if we could, before we delve into the full-blown Q&A, we're wondering if we could perhaps have a group-by-group debrief of what was discussed. Only if you're comfortable, just briefly sort of talking about what you discussed, and maybe that can lead to more questions. So whichever group is comfortable doing that, and if you have a spokesperson for the group, that would be great. So anybody interested in sort of just sharing what was discussed in the group?
In our group, we were talking about how the state of the surveillance state keeps advancing every time there's like a state of emergency, and that those who have interest in expanding surveillance have a concentrated interest, whereas we all have like diffuse interest in not having it that we don't even really completely understand. And so because we haven't really like even thought about this that much, we're just kind of being steamrollered, and it's like a ratcheting process, and that we actually really need to pay more attention to it.
Anybody else? Yes, Ellen.
Well, 2 comments in our group. One was that there's somewhat of a divide between us older generations and the younger generations in terms of concern about privacy, that many younger people do not seem to have the concern about privacy that we have, that they put everything out there. And the other one was that some of us think we're closer to a police state than has been acknowledged.
Great. Thank you, Ellen. Anybody else?
So we had some really interesting discussion. Something that Jeannie said that I thought was really interesting and really well put was, again, just a false dichotomy of national security versus privacy, and the fact that when you put it to a question like that, it's just not reasonable for people to answer in the way that is most observant of democratic rule of law. And also we got into a really interesting discussion about armed forces and their place in this, because we were talking about how communities and people who serve need to be educated and really know and have the information that they need based on that transparency to then serve their country, not blindly, because they're the people too. They need to have some role in that oversight. And so if we're able to kind of educate those people from the ground up, we can maybe make some more meaningful change in that way.
Yes.
Maybe someone in my group can help me out, because I can't remember the exact context that we were talking about this in, but we kind of talked about how for future generations can we maybe like make them more aware of the security and their privacy and everything, and these 2 are teachers. They have a good point. Raise kids with skepticism, so have them questioning everything, and I think that's really important to increase our awareness of our privacy and what we're giving away and everything.
Great. Thank you. Yes. Hi.
So we actually, you bringing this up is going back, talking about the foundation. We did have an interesting discussion about civics being taught in school and the importance of having a democracy. And this wonderful lady brought up George Washington, saying we have to have vigilance, constant vigilance. And without having the education of civics, we're not giving our youth that foundation, that solid foundation, and for them to make informed decisions about national security. It just even is that diffuse amount. And if I could just make one little comment, we talked a little bit about millennials and the privacy, but one thing I did bring up is I feel that we've kind of been going in this direction and we've been ripening it for the younger generation to release their privacy. I was talking about, well, I remember when I started having to give my social security number just to talk to my bank or something like that. And as soon as 9/11 happened, you know, we're talking the Patriot Act, and people are like, wait a minute, and the TSA, and it's like, this is all fear. It's not saying that we don't need to put some balance in place and some national security policies in place, but just going through it by fear and not by looking at the facts. So that also came up in our discussion as well.
Yes.
Another thing in our group I think is very valuable is the danger for people whose language is Arabic or other languages and just wanting to find out news, and that could leave a trail, you know, that I think is even more dangerous, and then also, you know, the kind of searches that politically oriented people might do.
Sure. Well, that's a lot of great information for you to help us process, Sudha. And is there anything in particular that you want to focus on?
Well, I'll start by saying one thing. So I appreciate this conversation about educating people who are in the military or in the intelligence community about these issues. One of the things I had the chance to do prior to writing this book was, or in the process of researching it, I guess, was talk to a bunch of people who work for the NSA. And that was a really educational and interesting experience for me for a lot of reasons. But one of them was this view that, that they were under a tremendous amount of pressure, right? That one of the things that came out after the September 11th Commission report was this idea that it was not a failure of military strength that occurred, but it was an intelligence failure. And it was a failure for the government to read the intelligence that was already available to them properly to put things together in order to prevent this attack from occurring in the first place. And when you combine the pressure that comes out of that kind of report that suggests the intelligence community needs to do whatever it can to prevent the next terrorist attack, with vague laws and a kind of a disengaged public who doesn't really fully understand what's happening, and then you also combine that with a zero tolerance for terrorism that we definitely have, unlike the way we treat most other violent crime in the United States, where we say, yeah, it would be great if we didn't have any homicides this year, but if we have one, we don't consider that somehow a societal failure or that our law enforcement mechanism has entirely failed. We use that kind of rhetoric when it comes to terrorism, right? Who failed when there's any kind of terrorist attack that occurred, even if the end result in casualties, and I'm not saying this to minimize this at all, there's obviously a huge human cost to these events occurring, but even when that's much less than you know, an instance of domestic violence, or much less than a shooting that might occur somewhere or anything else, our reaction to terrorism is very particular, and it's outsized in ways that distort the way that every other entity in our society works. And so this comes back to the NSA to suggest if they are being told we have zero tolerance for any of this ever occurring, not just large-scale terrorist attacks, but the smaller ones that occur as violence might occur in any liberal democracy. We don't have any tolerance for it. We have vague laws, a disengaged public, and you know, politicians who say that they want to protect civil liberties are being labeled soft on terror. It is not a good recipe for our intelligence community, for the people there who might have the desire to act conscientiously, to act with a little bit more regard for people's privacy. And so what's really important is building institutional structures to cabin what they do and to oversee what they do in ways that let them do their jobs the way that all of us see fit, but also have accountability mechanisms when something goes wrong. I actually think there's folks in the NSA who would welcome that structure if we were able to put it in place. But it's a matter of engaging on a lot of the stuff that you all talked about when I took notes on this, right? Having the public engage in privacy as a value that's actually important and a priority, engaging in civics education, you know, to tell people to be skeptical and to engage critically with their government, because frankly, that's what we should be doing in democratic societies. All of those things go hand in hand.
But does it really take a Trevor Noah video or a John Oliver video to really, dumb down the issue to the extent that it's easily accessible to people like us? I mean, how do we get that? As I said, it's so, the subject material is so dense, it's so complex. How do we get beyond that? And again, people are more interested in what's happening domestically and not so interested in counterterrorism operations abroad, drone strikes happening, how the US military is conducting itself in other parts of the world. And nobody has time, nobody sees the connection between that and September 11th. That and terrorism, US foreign policy and how that's connected to what's going on over here. So how do we make that link and how do we make it more?
So you ask a hard question, right? If people want to talk about the history of, involvement of European and U.S. powers in various Middle Eastern countries over decades and the way that it's destabilized regions, we could all have a really long conversation to try to draw the line there. But I think people have been trying to do that for decades, right? To say, there's ramifications to each piece of involvement that you have in different people's, in other people's countries, right? You invade sovereign nations, things are going to occur. I don't think that there's a high level of tolerance for that. And because of that, it allows government policies to keep moving forward without a lot of repercussions, either political repercussions or legal ones.
Yes.
I'm just struck every time we use the word terrorist, how that conjures up an image of a Middle Eastern or an Arabic, and the fact that we have much more domestic terrorists, it's not understood. And people just don't, the numbers of people who are killed by domestic terrorists far surpasses others. But somehow the term itself, terrorist, conjures up an image which is false.
In 2009, the Obama administration put forth a report dealing with the rise of right-wing domestic terrorism in the United States. It was actually a really thoughtful and interesting report that tried to be nuanced and not paint with a broad brush a lot of groups that would be considered kind of quasi-militia groups or whatever else, but tried to take an approach that suggested we should be on the lookout for terrorism there. The political blowback was immense on the administration, and that document was taken down from its website pretty quickly, and then you could still find it if you went through a bunch of searches, and then the Trump administration kind of scrubbed all of that kind of information off of the Department of Homeland Security website when it came into office. I think you're touching on a very germane issue.
The fact that we are not even aware of something like that, that's not something that the press focuses on, or anybody who could tell us that what our government is really doing. And I guess you've already mentioned this, because Congress, the oversight committees aren't functioning in any way like that now, for various reasons, but
It is difficult, right? I mean, we have certain mechanisms that we have in place for trying to conduct oversight. The congressional committees that you're referring to are one of the traditional ways of trying to uncover the goings-on in an administration when you're worried about abuse or overreach. And that has been, this is not the first administration in which those congressional oversight committees have been hampered by political imperatives, right? That's decades old, at least. So it's not new that that's occurring, but the other mechanisms we have in place are also not functioning the way they ought to. As Melaka referenced earlier, the idea that the Special Inspector General can't have access to all the information that he needs for the Afghanistan, to understand the war effort there. I mean, that's extremely disturbing, right? The idea that you're over-classifying information so that the public can't know about a lot of aspects of counterterrorism and war-making efforts in other countries that had been available previously is also disturbing. Even though these problems have been long-standing, they've all kind of come together in a more extreme form under this administration than we've seen previously. And I think, one of the things we were talking about during the break is seeing whether this administration will lead to people wanting to build better structures of good government, or whether everyone's just going to, whenever it's over, let's say hypothetically there happens to be a switch in control in one of the chambers of Congress or a switch in the presidency in 2020 or whatever else, if everyone will say, oh, now we can go back to the way things were. I don't know. I don't know which way we are ready to go with that. Because the kind of attitude that was under the Bush administration, the second Bush administration, and the Obama administration of, just trust us, we'll make good decisions for you on national security, it kind of angered certain slices of society, but it didn't lead to better institutional structures. If we can do that here, of leading to better institutional structures that are funded in a way that's not subject to kind of over-politicization, that the staffing of them can be structured in a way that you can actually maintain oversight, that would be a real victory. I don't think it would solve all these problems, but democracy is a messy business. If we could make some improvement on it, on the way we stay true to these values, I would think that would be a good kind of silver lining for a lot of the other things that are happening. And as you said earlier with your example with the TSA, every one of us has gotten used to taking our shoes off before going on a plane, even though there's zero evidence that that's actually helpful in maintaining security.
No, it isn't, but we think we're doing something.
That's right.
And that will protect us.
Yes.
How do you see that? I mean, can you give an example of what that would be?
Sure. So one of the suggestions that came out of the September 11th Commission report was the creation of a Privacy and Civil Liberties Oversight Board, talking about to try to see people who have security clearance, a bipartisan group of people who could kind of investigate what's going on in the government on an ongoing basis, and put a check on the intelligence agencies and publish reports occasionally, some declassified reports that could shed a little light on what's happening in the name of counterterrorism, particularly when U.S. citizens are impacted. That board was recommended by the September 11th Commission. It did not get staffed or funding until 2 months after Edward Snowden made his disclosures. And then it was fully staffed with 5 people on it. They were kind of up and functioning, and published a bunch of reports, really good, interesting, comprehensive reports on how it is that they thought the intelligence community was doing really good work in certain areas, how legislative reform could be helpful in other areas to help cabin off certain vague areas of the law that were being perhaps overused by the intelligence community. It did it with Section 702 that we were just talking about earlier. It did it with a bunch of Patriot Act provisions. And it was moving, right? It was up and running and moving, and it was bipartisan. I think even at the time, the staffers were 3 Republicans and 2 Democrats, but it was going through this writing of these reports. The people on the board had staff members who were fully funded and whatever else. Currently, right, this oversight board has 1 part-time member. Everyone else who has either left or has been let go and has not been replaced by anyone else. And the staff funding has been cut dramatically. So when you have an oversight mechanism that could at least do some good, not solve every problem, but at least help in some way, but it's subject to the administration deciding whether it exists or not and whether it gets funding, it's not really able to do its job in that way. And I mean, again, this is not limited to the area of national security. We know that various consumer protection, agencies and other things have been subjected to these kinds of budget cuts and political machinations. This similarly has had that happen. So if there's a way to structure that better, to protect the funding for that, to force something to exist perhaps statutorily, and that the funding is guaranteed year over year or for 10 years, the way that some other administrative agencies are done, I think that's a more protective of the kinds of interests we've been talking about.
Do we know what kind of technologies are being used in counterterrorism abroad and what may be used in the U.S. as well? I live in China, and the technologies used there, and facial recognition is, they can sort of find a person in 7 minutes in a major city, and there are new algorithms that if 2 people meet, who've never met before within a certain amount of time, then they can be targeted and this sort of thing. I'm just wondering if that's widely used by the US and overseas and what implications that might be for being used at home, or if other countries are using this as well.
So yeah, I think China is ahead of the field on this kind of technology with a lot of these programs like the ones that you're mentioning. I think other countries are using that, as you suggest, using similar types of technology, or perhaps not quite to the same level, but similar things overseas. But they are not, the US at least is not yet using it at home. Right? There's enough constraints in place that are protecting against that sort of deep dive of people's data and their lives, and in ways that are recorded and then used by the government to kind of catalog who people are and where they are at all times. I think the technology is available to do it, and this again will speak to the strength of our legal institutions. We do have, I think, a brewing movement in the court system to suggest that the right to privacy is stronger than what the government thinks it is. There's been a few court cases that have come out in the last few years that suggest that at least 5 to 6 of the justices who are currently on the Supreme Court are really dissatisfied with this notion that anytime someone goes out in public, that all of a sudden they're willing to give up any right to obscurity, should we say, when they're moving about in the public sphere. And so you have a couple of the more traditionally conservative justices like Justice Alito and Justice Kennedy, who have been very skeptical of government arguments that, you know, the fact that we all walked outside to get to the Jones Library somehow means that it's okay for the government to catalog what we're doing here or whatever else. So I think that's heartening, right? You know, as long as we believe that the court decisions are going to be followed and by the government, which I think we can have some confidence in that. I think that we have a judiciary that's willing to stand up to for at least some level of protections. Right? They're doing it in the name of the Fourth Amendment here, but I think that they're even thinking more broadly than that in some respects.
What about predictive policing and that sort of thing?
Yeah, that's a little harder, right? I think that, again, this goes to kind of this notion of political will. When it comes to policing, there's been, I think, a history of being much more receptive to this idea of preventive policing being something that we should at least try. If we think about how long it took to put a stop to like stop and frisk in New York City or other places, which is another form of kind of, you know, managing people before they commit crimes or whatever else. You know, I do wonder how much the technology will be used for that. And there's, I think, this is one of the many instances in which technology is outpacing the way that law and law enforcement works. And so I don't think people are fully thinking through what the effects of a lot of this technology is. As one example, I'll just give like the movement towards putting body cameras on police officers, which is kind of a very high transparency kind of operation in the sense that you're supposed to see whatever it is that the police officers see. You know, in some communities, it's actually shown to be detrimental because no one wants to call the police into their house at their most vulnerable moment if all of that is going to be on camera. And in some jurisdictions, you know, they post up raw body camera footage from the police on their websites because they want it to be available to the public so everyone can see what the police are doing. I think that there are unknown consequences that are occurring, and it will take some time to sift that out. And it will depend on the level of intrusiveness and whether it's happening to everybody or just a segment of the community to figure out how much that the courts will be willing to step in for that kind of predictive policing and stuff like that.
Have there been court rulings on the body cam?
I think they're winding their way through. I don't think they've quite gotten there yet. I know there's one case, I think, in Washington State that's occurring because there's a town there, and I'm forgetting the details now, where, again, the raw footage from body cameras has been posted up on the internet. And, you know, it's kind of like this horrible thing where people view it as some sort of weird reality show, but it's, you know, people at some of their worst moments and their most vulnerable moments in their homes, with all of that being broadcast widely. Talk about a lack of privacy, right? It's pretty remarkable. And I think there's like some class and race implications that come along with that were not thought out beforehand with suggesting that you put all this footage online.
Yes.
what about protections against data that's collected by private companies that the government then buys, such as the recent report about license plates being collected across the country and being sold to Homeland Security so they could track undocumented immigrants?
Yeah, so I mean, I think you raise a really good point here. I think this is one of the, there's two issues that come from this. One is that I think that lawmakers in general and members of the intelligence community think they undervalue the public's view of their own privacy, because their view is, well, they're willing to give all their information to Facebook or to, you know, whatever X company, so therefore what's the big deal if the government dips into that trove of data as well. And the second part is, I think an assumption, an incorrect assumption that people understand what's happening with their data as they just kind of go about their day in the world. I think it's very rare that people read the terms of use for the contracts that they enter into. I think I'm one of the few people who irritatingly goes through them, and I'll tell you that when I bought my cell phone last year, I sat in that Verizon store for about 2 hours reading the terms of use, and the salesperson asked me if I was a spy, which was I don't think you can expect necessarily. I think it's unreasonable for people to expect individuals to read and understand what's happening with their data. Even the places that say, we protect your privacy, and they have pretty strong language in there, almost every one of them has a disclaimer that says, unless your information is necessary for law enforcement or security purposes, in which case we will share it. Or if it's subject to a subpoena, we will share it. Those are really loose terms, right? If we talk about terrorism being kind of a loose and misused term, security is also a very loose term, and getting a subpoena can mean a lot of different things, but most companies just comply with it. And as of 2008, a lot of telecommunications companies have immunity from lawsuits for sharing the information with the government. And so, you know, you're really in a situation where you cannot control the way in which your data is being used, but courts continue to operate as though people are making affirmative choices to say, oh yeah, well, of course it's okay for Verizon to, you know, share my information with whomever, because it says so in the contract, and I eventually did buy that phone, so, you know, I signed up for it. I think that this is another area where, you know, people will suggest, well, aren't they willing to trade off privacy for the convenience of these devices, or going about your day and getting, you know, whatever software you want or whatever else. I would suggest that that's the moment at which regulation is actually the most important, that you are able to step in and say, this is a role for government here. The EU, again, has done a much better job than the US on data protection and data privacy rules, suggesting that companies can't monetize this data the way that they had been doing for a long time. And in fact, there's some new data protection rules that are going into effect there that have been contested, right? A heavy amount of lobbying and litigation in the European Union to try to prevent these regulations from being enacted, that basically suggest that Facebook can't move user data around the way that it used to. Google cannot track people the same way that it used to. And you know, that's a different model, right? It's not the kind of free market model that we seem to give primacy to. And it's suggesting that different values are more important than that. Maybe it's less convenient for the users, or maybe they have fewer pieces of software that are available to them, but their government has made it, or I guess European Union governance has made a determination that values like privacy and what they consider to be personal dignity are more important than that. The end result of these agreements is that Facebook users in Europe have so many more protections over their data than Facebook users in the United States do. Even if those EU persons move around to different jurisdictions, come to the US and go back again, those protections go with them because they're EU citizens. And so they have a lot more control over that kind of thing than we do.
Yes.
Do you have some practical things that ordinary people like us could be doing, should be doing? Are there some stories or examples you can give that would be helpful to us?
So I guess I have a couple of suggestions. One would be to stay engaged on these topics and actually talk to your politicians about them. I think that particularly at this time when there's a lot more stuff that's in the news that gets noise, that you don't see reporting about it in the press the same way you might have seen under a different administration. You don't see Congress people really focusing on this kind of thing. And so reminding them that it's something important to you is, I think, a really helpful tool. I think we've all seen lots of reporting in the last year about how, on any particular issue, it's really important for people to engage and call their Congress people. That holds true for this as well, because, again, these are complex, not the most exciting issues in terms of like being a neat headline to put up in the newspaper, but they need people to pay attention to them. In terms of your everyday life, I think it's a little bit harder in terms of managing how if the question is about how your data is being used elsewhere. I think there are certain people who take measures like encrypting their messages and using certain private servers and other things in order to protect their data from government view. I think those have mixed rates of success, but for some folks that's important for them to do, so they do it.
So, we have FISA courts,
Mm-hmm.
and they have a role, right? Do we need them, and if yes, are they working, and if not, what is there to do about them?
Yeah, you ask a good question. So this is a question about foreign intelligence surveillance courts. You may have seen this in the news recently because there's a memo that might be coming out shortly in the next few days detailing the way that Rod Rosenstein, a deputy attorney general, reapplied for a FISA warrant to the Foreign Intelligence Surveillance Court to conduct surveillance on a Trump campaign aide in 2016. So this is the context in which we've seen it, I think, most recently in the news. This is a court that exists. It was a kind of a compromise creation that occurred in the late 70s, again, at this post-Watergate moment when the idea was to bring more light to what the intelligence agencies are doing. And what it suggests is that under certain circumstances, the FBI or other agencies need to seek a warrant, a FISA warrant. It's the same idea as a judicial warrant, but you don't need the same you don't need to meet the same standard in order to get surveillance authorities. It's a secret court because it's dealing with surveillance issues. It's a closed court proceeding. Until 2015, it was completely non-adversarial, meaning only the government lawyers were presenting their arguments. And the court does not need to publish its opinions, right? It can keep them, they're initially classified, and then it used to declassify them very rarely. A lot of critiques of this court, particularly in light of the Edward Snowden disclosures. And ultimately, with some reforms that occurred in 2015, there's now occasionally an adversarial process that occurs if the court feels like there's a new issue that they need to decide. They can bring someone else to argue against the government. There's the opportunity to publish or encouragement to publish more of the opinion so people can see what this court is doing. But it's still a court that basically it grants most of the warrant applications that come its way. This morning I was looking at the 2016 data. It was something like 1,800 FISA applications went in that year, and all but 9 had been approved, at least in some way, or at least partially approved. So it's a pretty high success rate if you're going in front of the FISA court, which makes it particularly interesting that there's a real argument that somehow the FISA court is acting in extraordinary ways by authorizing this surveillance authority against Carter Page. But, the court exists to be this uneasy middle ground, this way to try to convince the intelligence agents to actually go through this regularized process to gain authorities. And I think part of it is the reason it continues to exist is a fear that if we got rid of it, what would be the alternative? Would it just be having intelligence agents tell you, oh no, we're not doing anything, don't worry about it, but kind of going to ground and actually doing whatever they wanted to do, or keeping secret the entire process that they're undertaking? Is this like imperfect process at least better than nothing? And if we make it much more rigorous and we make it harder for people to get FISA warrants, does it mean that they just will engage in surveillance without telling anybody about it because they want to bypass the process altogether? And I don't think that there are easy answers to that. I think that the fast answer from the intelligence community would be like, no, of course not. We will comply with whatever law you put before us. But, you know, I think it's unclear. And I think a lot of people feel uncomfortable with putting too many constraints on the intelligence community too, because again, if we think that they're a key component to counterterrorism, there's a desire to give them some leeway in the work that they're doing. I don't know if that fully answers your question.
Yeah, it was, yes. I mean, it's kind of a rhetorical question, right? There's no good answer to it. But I always wonder, does it make sense to have, like, you know, pick a random time, a decade, you know, and then we get to see the decisions or something? I mean,
yeah.
It just, I don't know, it's a bad system.
Yeah, I mean, you could create something like that where you created a default mechanism to say, after 2 years, right, the default will be that this opinion becomes public unless you put, you know, the director of national intelligence or someone else petitions for it to stay closed and shows us a reason why, right? You could do that. I think those measures might be palatable under some circumstances. We haven't gone there yet.
Well, I guess the question is, if 1,791 out of 1,800, you know, requests were granted, is that real oversight?
So, I mean, this is a fair question because it's in a lot of people's view, this is a rubber stamping court. I will say that the FBI agents who who put together these FISA applications, they're pretty long and detailed, right? It forces them to write down both the factual basis for the surveillance that they want to engage in, and it forces them to put the legal basis. They need to consult a lawyer before they kind of finish off their application and it goes to the court. And the lawyer has to say, here's why the facts suggest that we've met this reasonable basis standard. So there is some self-policing and internal vetting. I've heard FBI agents say in the past, with the number of hours it takes to put together one of these applications, you're not going to do it if you don't have a good reason to try to surveil someone. So that part of the process is somewhat of a deterrent to over-surveillance. That being said, I think even judges on the FISA court have said in recent years, we can be asking a lot harder questions. If we had an adversary who was there all the time, that would force the government to really, really think through whether they needed to surveil these individuals or not. And so I think additional reform is possible, but whether it's likely or not, I guess is a separate question. But it's not a completely limitless process that anytime the FBI wants to surveil someone, they can just walk right in and get authority to do that. And I mean, that's part of the reason in this current news story that it suggests that there may be a reason why the FBI continued wanting to surveil this Trump aide. Not to say, I mean, I haven't seen any of the underlying documents or don't know what they found, but to suggest that they had to put together a packet of information to bring there. They can't just say, hey, we want to do this, which is sometimes how it's characterized.
I'm wondering how this compares to the success rate for domestic warrant requests.
It's significantly higher than the success rate for domestic warrants, partly because you have a different standard that's in place for criminal, domestic investigations. And I think partly because all of these, the things that are done in ordinary courts are much more open to investigation and to questions later on in ways that this particular court and this particular type of surveillance never is. We don't have an obligation to turn over evidence that is gathered in this surveillance to the individuals in a criminal trial, or in the same way that we do with other kinds of warranting processes. So there are many, many fewer places for both self-policing and external oversight of the process.
But domestic warrants, even for somebody who's suspected of terrorism here in the US, would the same standards apply? Are they just as rigorous?
That's a fair question. I think that, again, as with many things, once terrorism is invoked, there's a much greater willingness on the part of courts to grant warrants, to conduct surveillance. And so I don't know what the answer is. My guess is that it might be a very high percentage under those circumstances as well. That's a really good question.
Luke, you had a question?
Yeah. I was researching some current legislation for this event, and there wasn't much, I'll be honest, right now in this current Congress that tries to put more transparency on national security agencies. But there was one bill that stuck out to me just because of the title. This is sponsored by Jackie Walorski, who's a Republican. And it's H.R. 700, Transparency and National Security Act of 2017. Very much on topic to what we're talking about. And what the bill did is it applied the requirements of the Freedom of Information Act on the National Security Council. And I don't know enough about the National Security Council or the Freedom of Information Act to really know what that means necessarily. I did some more research, but I was wondering if you could speak to that and if that is helpful right now.
Yeah, I mean, I guess it's helpful in the sense that I'm glad that some member of Congress is thinking about this and is interested in promoting these ideas. I mean, it's hard. I'll be very interested in reading what this bill says. I think that the National Security Council is an entity that has, again, self-policed in terms of how much it's wanted to disclose in the past of its meetings or its findings or its decisions. Generally, the conversations that are in there might be covered by one or more privileges, right? There might be a call for executive privilege or some other sort of classified information designation that would prevent it from being disclosed. The Freedom of Information Act itself has exemptions for both of those things, right? Executive privilege, classified information that cannot be declassified, after going through a review, and it has a huge national security exemption. So I would be curious as to what this bill is trying to achieve. I'm glad it exists, right? But,
So any more questions? And just so you know, Professor Setty has been very gracious in offering, she is open to any questions that are not strictly on the subject, but any constitutional questions that you have, because she is a constitutional expert. So any questions about the Mueller investigation or anything else that might be of interest, so we can maybe do one more question. I know that, the State of the Union is coming up, so people might want to go back home to that. Even though there's some shakings of the head. But if people have, maybe we can take two more questions, perhaps.
Mine was actually going about the memo that's supposed to be coming out, and I guess what I'm trying to understand is when I think of a memo, it sounds more like an opinion, it doesn't sound like a fact. I don't really understand how that's supposed to be proof, or I'm really confused. I don't understand the meaning of a memo with that. I understand he's trying to show that the FBI did something wrong or something like that, but it sounds like there's another memo that has other, so I don't know, it just sounds, I don't really understand what proof comes with that. And
yeah, I think you join many people, right, and not fully understanding that. I think that none of us know what this memo says right now. The president has a few days to decide whether to allow it to become public or not. It's kind of extraordinary in the sense that the memo has classified information in it. And so the reason it needs to go through the president is because he can independently declassify information if he wants to. And so he would need to do that to publish this memo and get it out in front of the public. I think it's extraordinary. You don't see this every day, where the Justice Department and the FBI and various people who are Democrats and Republicans are perhaps objecting to the disclosure of this particular memo, partly because I'm not sure that they see that it would shed a lot of light on this situation, but also because of the classified information. I think one of the difficulties here is, from what I understand, which is only from the same news reports that everyone else has seen, that the memo contains kind of a selective reading of how this investigation into Carter Page unfolded, and doesn't necessarily give a full contextualized picture of what kind of factual sources this FISA warrant application relied on. I know there's also a secondary memo that did not get voted out of committee, so that's not going to be declassified right now. So there's a concern that even this process now that it's being undermined. I mean, I think it would be much more comfortable if the Justice Department itself said, here are the steps that were taken, or they, there was a declassification of part of the decision to grant this FISA warrant, or something along those lines that would be more of an institutional document rather than something that seems very political.
Oh, right, okay.
Yes.
So I got a new topic for you. Just maybe here at the end, I was talking with my class today about Guantanamo, which many of my 10th graders had not actually ever heard of. So good, education happening. But I mean, what's an update on the Guantanamo detainees and the state of them a year into the Trump administration? Maybe you could just talk for a minute about the latest.
So I'll make two observations here, and thank you for being one of those civics educators who are telling people to learn about these topics and question them. But one is that President Trump, when he was a candidate, initially made many comments about wanting to fill up Guantanamo with, I think, bad dudes was the term. And I'm glad to see that nobody else has gotten moved there. I think that that's actually a really good sign. Whether it's done for political consideration or otherwise, I think that that's very good. There is, some lack of clarity about individuals who've been detained by the U.S. elsewhere who have been not given access to lawyers or contact with family, and an inability to, I guess they just got legal, these detainees just got legal counsel recently. But, there's been, the Trump administration has basically detained people elsewhere outside of Guantanamo in order to lessen, I think, the poor optics that come with Guantanamo. Another thing that's interesting is that there's some Guantanamo detainees that have filed a lawsuit recently saying that they're being held based on anti-Muslim bias at Guantanamo as opposed to because of military detention purposes. And they're using President Trump's comments while on the campaign trail and while in office to suggest this. To me, this suggests that they're trying to take the same tactic that occurred in the litigation around these travel bans to see if it would be successful in this context. I think that that's a really big uphill climb for them, but that's it's interesting to see that 16 years in, they're still trying to get creative litigation strategies to try to challenge detention there.
Well, I know you said no more, just creative litigation strategy. So, perhaps not obviously, but I do watch the Mueller investigation with equal amounts of, interest and hope. Mm-hmm. But I'm interested in your thoughts on the litigation on conflicts of interest against the president, and whether or not you think that has any real viable path forward, kind of just as a in a judicial perspective of kind of, really, they just seem so blatantly kind of there.
Yes, I think it's hard to, for me, it's hard to see those cases moving forward with a great deal of success. I know that there have been a couple of cases that have been dismissed already, having to do with the emoluments clause and this idea of accepting gifts. And so I think that the conflict of interests, although perhaps evident here in ways that are different than other presidents in the past, are still murky enough and kind of not directly connected enough in a way that courts might feel uncomfortable wading in and finding a conflict of interest to exist. I will say with regard to the Mueller investigation is that it will be interesting to see how it goes forward. I think he's been branded interestingly as some sort of progressive firebrand by the Republicans. And it's interesting that he has been on the defense side of litigation for the last 16 years because of detention practices and everything else that occurred post-September 11th that the FBI was on the hook for. So, a Supreme Court case that just got resolved last year had him as one of the defendants as the person who allowed for the lengthy detention of people who appeared to be Arab or South Asian in New York under very extreme and abusive conditions in New York for months, and that's the same progressive firebrand who's supposedly running this investigation. So it's interesting to look at the context.
Great. Well, thank you all so much for your very interesting questions and your interesting and thank you so much.